In this video, we're going to be talking about the next section of the rules, specifically transactions and communications with persons other than clients. And to get started, remember that this section of the rules makes up 2 to 8% of your total MPRE exam. The first rule that I would like to direct your attention to is about truthfulness in statements to others. It's a fairly loaded rule, so let's start by looking at the language of the rule and then we can turn to some examples. The rule states that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. So to stop there, this means that while you're representing a client, you as a lawyer shall not lie. Whether it's about a fact of your case or about the law, you shall not be lying to anyone. The next part of the rule says, in the course of representing a client, a lawyer shall not knowingly fail to disclose a material fact or law to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by the rules of confidentiality. So there's a lot to unpack with this part of the rule. First things first, this rule is saying you cannot lie by omission. Failing to say something, if that failure to speak amounts to a lie or misrepresentation, is then a rule violation. This rule encompasses what you say, but it also encompasses failing to act or failing to speak when you should be. Thus, if you lie by omission, you're still lying, and therefore it amounts to a rule violation. Additionally, the rule states that we shouldn't allow our client to use us to commit a crime or fraud. So, for instance, if you know that your client is failing to disclose something and that failure to disclose something amounts to a crime or a fraud, then you have to speak up. Because again, failing to do so is lying by omission and is therefore a violation of this rule. Another thing I want to point out is that this prong of the rule points us back to our duty of confidentiality that we learned about previously in the course. It says that if there's an exception to our duty of confidentiality, which remember, there are multiple, that allows you to disclose a client confidence in an effort to avoid assisting your client in some sort of criminal or fraudulent act, then you must. In other words, it turns the mays under our exceptions to the duty of confidentiality into a must. So let's look at the example in the outline. It says a lawyer is assisting a client in the sale of a building. The building has asbestos, and both the lawyer and the client know about this fact. The failure to disclose known asbestos is a crime in the jurisdiction. The lawyer does not correct the client's disclosure documents, stating that there is no asbestos in the building. Lawyer will be subject to discipline for this. So to expand on this example, this is because there is an exception to the duty of confidentiality that would allow the lawyer to make disclosure in this instance. And therefore, the lawyer has to make that disclosure to avoid committing the crime. If not, then they violated the rule. So moving on, the rule goes on to tell us that misrepresentations can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows to be false. So, for example, going back up to that asbestos example, if the lawyer signs off on this paperwork that the client made these disclosures on, then guess what? The lawyer just affirmed that information and therefore is liable for that. But the other thing to keep in mind is that this rule is trying to be fair. The rule goes on to state that under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact, such as estimates of price or value placed on the subject of a transaction, a party's intentions as to an acceptable settlement of a claim, or the existence of an undisclosed principal, except where non-disclosure of that principal constitutes fraud. Thus, this rule strikes a balance between those instances in which a lawyer knowingly lies or lies by omission or misrepresents information and is otherwise doing her job ethically, advocating on behalf of a client or trying to negotiate. Therefore, not every single thing that a lawyer says amounts to a statement of material fact. Turning to the example in the outline, it states, my client wants to take this case to trial. So settlement discussions seem pointless, but I'll listen to what you have to say. This is puffery and would not be a violation of this rule, even if the client did, in fact, want to settle. The next rule that I want to discuss is about communications with represented persons. The first part says that in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has consent of the other lawyer or is authorized by law or court order. If the lawyer learns that a person to whom they're speaking is represented by a lawyer, then the lawyer must immediately terminate communication with that person. So, stopping there. This rule is saying that if a lawyer is representing a client who is suing someone, and let's say that opposing party is represented by a lawyer, then the lawyer should only be communicating with the other party's lawyer. Now, if a lawyer talks to someone and does not know they are represented, but then comes to know that they are in fact represented by counsel, then the lawyer should terminate that communication immediately. Thus, it's very wise for a lawyer to open up conversations with someone by asking if they're represented. This way, the lawyer knows whether or not they can move forward with that conversation or not. The other thing I want to point out is that if a law or court order is allowing you to speak to someone who has representation or a lawyer, then you can. But generally, you should just be talking to the represented person's lawyer in the matter. A few things to keep in mind about this rule. It applies even though the represented person initiates or consents to the communication. So, for example, let's say a plaintiff's lawyer files a claim against a neighbor. The lawyer may call the neighbor personally and ask if the neighbor wants to talk about the merits of the claim. However, the lawyer may not appear disinterested. As soon as the lawyer finds out that the neighbor is represented by counsel, the lawyer is not permitted to discuss the claim with the neighbor. It must go through the neighbor's attorney, even if the neighbor initiates communication or the neighbor insists that he wants to talk to the lawyer without his attorney. Note that this rule only applies to the matter of the representation. It does not prohibit communication with a represented person or an employee or an agent of such a person concerning matters outside the scope of the representation. For instance, let's say you're representing Bob in a car accident case, and Bob is suing Alan, who's represented by a lawyer. On the morning of Bob's deposition, you show up to the office and notice that Alan is right behind you. So if you want, you can hold open the door for Alan as you enter the building, and you can say, "Nice day, huh?" Or "Isn't the weather beautiful?" Why? Because those comments have nothing to do with the car accident case, and you're allowed to have that type of communication or interaction with someone who is in fact represented. The prohibition on communication with someone represented is as to the scope of that representation. Because again, they're represented. So you should only be speaking to their lawyer or whomever is representing them about the matter. Now, we're not quite done with this rule yet. The next part of the rule discusses organizations. Many people struggle with this rule, so hopefully we can pull it apart and make it a little bit more manageable for you to understand. The rule uses the word organizations. But if it's helpful for you to think of organizations as a corporation, then do so. This rule is broader than just corporations, hence, it uses that word organization. But we find that if someone struggles with this rule, it is helpful to think of what this rule means in the context of a corporation. So, the reason we think this rule is tricky for most people is because with a basic lawsuit, let's say A sues B, we know very clearly who the parties are, A or B. But when it comes to an entity or an organization suing each other, an organization like a corporation is not a person, but instead it's ran by people. So it becomes a lot more challenging to determine who is the client and therefore who the lawyer can and cannot talk to. And that's what this rule speaks to. The rule states, in the case of a represented organization, the rule prohibits communications with a constituent of the organization who supervises, directs, or regularly consults with the organization's lawyer concerning the matter. So let's stop there. Let's say that you're an employee of a big corporation and you got fired, but you believe it's wrongful termination. Specifically, you believe it's in breach of your employment contract. So you hire a lawyer to sue your ex employer, this big corporation. As it relates to this rule, the corporation is the opposing party. The corporation has counsel. So if there is a CEO who has regular contact with that corporation's lawyer, then your lawyer shouldn't be talking to the CEO as it relates to your lawsuit. What this rule is saying is your lawyer should treat that CEO almost like they're the opposing party and should talk to the corporation's lawyer directly instead. The next part of the rule says in the case of represented organizations, this rule prohibits communication with someone who has the authority to obligate the organization with respect to the matter. So, going back to my previous example, if the board of directors of the corporation that you're suing has the ability to settle the case that's being brought against them, then your lawyer shouldn't be speaking to the board of directors directly. Your lawyer should instead be speaking to the lawyer that represents the company. The next part of the rule states that in the case of a represented organization, this rule prohibits communications with someone whose act or omission in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. Again, if there's someone working on behalf of the corporation that can get that business in trouble, then your lawyer should not be speaking to them directly, but instead should speak to the corporation's lawyer. Turning to the note in your outline, consent of the organization's lawyer is not required for communication with former constituents. But be careful. Let's go back to our original example. You're employed by a corporation and then they fire you. You think it's wrongful termination, so you hire a lawyer. Let's say that corporation's CEO quits. Well, your lawyer is allowed to speak directly to that ex-CEO because they're no longer a part of that company. However, your lawyer is not allowed to ask them to break any sort of confidentiality or attorney-client confidences that maybe they've had with that company's lawyer. So, is your lawyer allowed to speak to that former CEO, the former constituent? Yes. Is your lawyer allowed to violate the rules otherwise? No. Finally, the rule says that these rules do not apply to represented persons communicating with one another. So, turning to the example in the outline on this point, ex-husband and wife each are represented by their own attorney in a bitter divorce action. While it's not proper for a husband's attorney to talk to the wife without counsel and vice versa, husband and wife are permitted to discuss the matter amongst themselves. The final rule that I want to talk about is about communications with unrepresented persons. Thus, now we're talking about the opposite situation of the rules that we were previously discussing. The rule starts by saying, in dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that he is disinterested. Therefore, this means if you're representing someone in a matter and the opposing party doesn't have a lawyer, it's impossible to move that action forward without speaking to the unrepresented party. You have to be able to communicate with them. And the rule recognizes this point. However, you have to be careful in speaking to them. You can't act disinterested. So, for purposes of the MPRE, please read the quoted language very carefully. If they do provide you with language and quotes, circle back to it and always double check it. Because the idea is if you're hired by someone and therefore they're your client, you aren't disinterested. You're very interested. You're supposed to have your client's best interests in mind. So you have to be very careful with how you speak to someone who's unrepresented. Now, when the lawyer knows or reasonably should know that unrepresented person misunderstands the lawyer's role in the matter, then the lawyer shall make reasonable efforts to correct that misunderstanding. So if an unrepresented person keeps coming to you and it's very clear that they're confused about who you are and your role in the matter, maybe they're asking you for your advice, you need to take steps to keep reminding them that you are not their lawyer and you do not have their best interests in mind. Lastly, the lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel, if the lawyer knows or reasonably should know that the interests of such a person are or have the reasonable possibility of being in conflict with the interests of a client. So, what does this mean? Some people think that the very first thing you must say to someone who's unrepresented is that they should get a lawyer. And that is not the case. That's not what this rule is specifically saying. What this rule is saying, if you're representing a client and there's an unrepresented person you're dealing with that has a conflict of interest or a potential conflict of interest with your client, you should not be giving them legal advice because doing so would create a conflict of interest. So, in such a situation, the only legal advice you should provide to that person is that they should get a lawyer. The other thing I'd like to point out about this rule is it's generally saying we shouldn't be going around giving legal advice to people who aren't our clients. Generally, we should be representing our clients and taking care not to create a conflict of interest. So, if there is someone not represented and they're coming to you or seeking help, you need to clarify your position, and the only advice you should be giving them is for them to go out and hire a lawyer. That wraps up this section of the